Hello, Florida Realtors. Happy 2026. Thank you all for joining us here today. My name is Juana Watkins, and I have the privilege and honor of serving as your Florida Realtors Vice President of Law and Policy and General Counsel. So, new year, new forms update. That is what we're here to talk about today. Yes, we are updating even more forms. Later, Heather Rhodes, my amazing Associate General Counsel here at Florida Realtors, will talk to you a little bit about why we are updating forms. But I just want to let you know there are a variety of reasons, whether it is regulatory changes or legislative changes or case law that we monitor that causes us to need to update these forms for you. So please be patient with us and understand that anytime we do update forms, it is a very deliberate decision that is a part of your amazing policy making process here at Florida Realtors. So, few housekeeping matters. We always do this as a part of our webinars. We want to let you know this is going to be posted to our Florida Realtors website, and we hope that you will use this regularly as a part of your office meetings, as a part of any educational offering that you do at your local associations. We hope that you will disseminate this content far and wide so that members feel empowered and comfortable with the changes that we have made to these forms. So look for this recording as well as the slides that Heather's going to cover to be posted to our website for your use. Now, without further ado, it brings me great pleasure to introduce one of the amazing senior attorneys here at Florida Realtors, Heather Rhodes, Associate General Counsel.
Thank you, Juana. I
Thank
appreciate
you,
that.
Heather.
Before we jump headfirst into the forms, there's one last housekeeping item that I want to address, and that is our antitrust statement. So I'm going to just take a moment to read this before we get started. Florida Realtors is devoted to improving the competitive business conditions of the real estate industry. This meeting or this recording, may include real estate professionals and their other industry stakeholders who compete with other or work for competing businesses. Florida Realtors is committed to conducting all meetings and events in a professional, ethical, and lawful manner, including an adherence to all antitrust laws. To that end, the topics of this meeting this presentation will focus on advancing the interests of real estate professionals and consumers of real estate services, increasing competition, reducing risk for all parties involved in real estate transactions, and sharing insights on business best practices. So the following discussion topics are always prohibited: agreements to fix prices, limit product or service offerings, allocate geographical territory or customers, and refuse to deal. And any discussion inconsistent with this policy will not be tolerated. And now that we've mentioned our antitrust statement, I do want to launch into a little bit of context before we get into the actual changes that have happened or happening this year into early 2026. So, part of the forms process, if you are not familiar, it is a process. And so what happens is there are two hardworking committees comprised of peers and attorneys in one committee that are dedicated to keeping your forms current and relevant in an ever-changing real estate environment. So the first committee I want to mention to you that you are to be aware of is the Forms Content Committee. This is a committee of your peers. They spend relentless amount of hours and time thinking through forms, suggestions, and changes, things that have come their direction to stay relevant in your market. So they're, again, a peer-driven committee, and they're just only one of two. The other committee is the Realtor Attorney Joint Committee, which also has a subcommittee, and they are focused primarily on the Florida Realtors, Florida Bar forms, the contracts, and the writers that accompany those two contracts. So keep in mind, two committees working tirelessly through the year to produce and keep forms content current and relevant for your use. And so I just wanted to make sure you are aware it is a process. It is not an overnight process. Some of these changes that we're going to talk about today are about a year old, things that have been on the table and discussed multiple times in the past year. And they have to go through many, many hands before they become a form. So not only does the committee hear these these suggestions or start talking about these changes, then our leadership team here at Florida Realtors also looks at them. And for one committee, the Florida Bar looks at these. So many eyes, many hands are upon these before they even become available for your use. So the last thing to keep in mind is to know what's available. And that's why we're here, right? We want to ensure that you know what's available to you for use in your forms library and what's in your toolbox as tools to use. And that's what these are going to be. So I'm going to move us ahead. And I want to just give you a little trivia because I train and have been to different associations throughout the state, talking about forms, training on forms, and there's a lot of misunderstanding or a lot of just mystery to how forms are made, but also to what's in the library. So I want to make sure you know. As of today, there are 167 Florida Realtors forms in the Florida Form Simplicity Forms Library. That does not include your brokerage forms or local specific forms that may also be included. So you may have more than that that's available to you. But 167 of those forms are from Florida Realtors and they are available for your use. Now, with so many forms, it's worth knowing that there is a forms description list. It is now included in Form Simplicity, so you can find this description list while searching your forms. And it is also included and has always been included on the Florida Realtors website at floridarealtors.org. And these are to help guide you to knowing what forms you have. And in this description list document, it'll give you the name of a form and a brief synopsis, so you know what the form is intended use is and will be. So with that, I want to bring a little fun fact to you, because when we talk about how hard these committees work to bringing forms, there have been some unprecedented years in the past 2 years. So in 2024, there were 65 form changes. No, you did not read that wrong. 65 form changes. This includes updates to revised forms as well as new forms. Now, 2024 brought along the NAR settlement, and that's where a majority of those changes belonged. But we also have a very active legislature, and there are more changes that were also included because of those statute changes. Then we followed up in 2025 with 25 form changes, again, including updates and new forms. We have a significant decrease from 2024, but that's still a lot of form changes. And we completely understand that there is something out there called form fatigue. You're tired of forms and new forms and more forms. Well, I hate to tell you that there's still some things we're going to cover today, and there's quite a few, but we are starting to see the decrease, right? We're coming out of that. So the committee, both forms committees, are really intending to look at streamlining forms, streamlining the process, being consistent across the board in the forms library to make these easier to use from time to time. And so that if you learn it on one form, it's not going to look different when you go to another form. So some of these changes we're going to talk about really are about improving, streamlining, and being more consistent in our forms. So we've talked about 2024, we've talked about 2025. Well, today we're going to look at what's coming this year in 2026. And so there were forms that were approved in November and December from the leadership teams. And here we have 17 forms to be released today. So the reasons for these updates in this wave of changes, they're driven by legislative or statutory ordinance changes, things locally, as well as NAR policy changes. We have committee approved changes. Those are things that the committee decided as they were looking at the forms to better improve the forms. So they're not regulatory in any way, but they are just, again, as practically used in your daily business. Then there are form suggestions. The Forms Committee receives suggestions from members like yourself about the forms that we have or for new forms. And so those suggestions are considered at the meetings and they are discussed openly. And so there are times suggestions come through and forms change because of those things. So we're going to take a look at several different forms coming up, but they will be in one of these 4 buckets. So it'll either be legislative, NAR policy change, a committee approved change, or a form suggestion. The one thing you're going to see carrying through for today is that all the changes are in red. So black text is what has always existed or been existing in the previous revision. Red indicates new and updated language. If it is actually new, it is underlined and red. If we've removed language, it will still be red, but it'll have the strike through line through it. So as we go through several of these pictures, that's going to carry through for all of them. And so let's take a look at the first bucket of changes. Let's take a look at legislative and ordinance updates. So the first update to talk about, this was a local ordinance from Miami-Dade County that has changed a while ago. And so the form is catching up with the way the law is currently in that area. So the Miami-Dade septic tank system disclosure has been available for a while now, and this is its first update. So again, the language in red is new. And so because the code changed, the code in this area in Miami-Dade County specifically gave this statutory language. So this was not drafted by anybody other than the local legislature through their ordinance process. So this is really talking about what we call on-site sewage treatment and disposal systems. And so the requirement here is for a seller to disclose what type of system they've upgraded to, whether it's 1, 2, 3, or 4, or not at all at this point. So it starts off with this paragraph, this longer paragraphs of text, and then it moves into these options for the seller of the land to further disclose. The reason we point these out, again, this is ordinance-driven language. So this is local law. We would want to point our sellers, if they are unsure about what they have installed, because they may not know, to point them to look back at any of their documentation or to talk to their own attorneys if they had attorneys working through them. This is not something we want to decide for them, but we want to point them to this to make sure they're aware. Again, they may or may not know, but this is something for them to do some research to and maybe contacting the county if they had to. So just know this is a Miami-Dade specific form. It's only for Miami-Dade, and so anywhere else we may not use this, but I just wanted to draw your attention that this is one of the forms that was changed based on this ordinance update. The next form I'd like to move into is the exclusive right of lease commercial form. And so this form has 2 updates. The first I want to discuss is the termination of the business rent tax. This was a huge win in the last legislative session, and so we updated the form based on that. It does also include an NAR MLS policy, so for being brief and keeping consistent, I'm going to address both of these together for this one form, just because I'd hate to keep bouncing around. So the language that we're looking at for the tax purposes, the removal of the business rental tax, is really simple in the form of the way it looks. We're removing language, this is the strike through, remember. So we're removing language for the including or excluding sales tax because there is no longer a tax to be had. And so that is the only thing you're going to see in this section is the removal of those 3 sentences after those check boxes. And that, again, brings us now into legal compliance with the way the statute and the laws are now written. The second change we mentioned was the NAR MLS policy for the multiple listing options for sellers. This is going to look very familiar. So we'll cover it at this point. And so in this paragraph, we're talking broadly about advertising. And you're going to see the word owner because, again, we're talking about leasing. So it won't say seller, but owner and broker agreed to adhere to each local MLS's policies and further agree to execute any applicable forms as necessary. Each MLS may have rolled out their own potential policy about this, so we leave this broad enough for throughout the state to defer back to your local MLS for what policies they have instituted regarding this new MLS policy. And so just know that this is here. It's a broad coverall. We're always just going to agree to defer back to the local association or the local MLS for whatever they have implemented to ensure that we are keeping compliant. The next form, again, shifting gears completely, we're looking at the receipt of condominium and cooperative documents. So what's new here is in red. We're looking at the turnover inspection report. In Condo 3.0, there was a provision to include, which we did at the beginning of 2025, to update the language in the condo riders. So when we updated the condo riders, it now talks about the milestone inspection report, what we call the SIRS, or the Structural Integrity Reserve Study Report, and it included the turnover inspection report. Well, this form did not already include the turnover, so it's just being updated to comply with the condo laws as they are now. And again, more completely reads with the condo riders, whether using the FAR form or the CRISP form. Okay, so this takes us to our second bucket, NAR policy updates. First, we're going to take a look at the exclusive brokerage listing agreement. This is another one of our exclusive agreements, like our residential sales exclusive right of sale listing agreement, slightly different, very minor language changes from those forms. But again, we still have an applicable MLS policy for the multiple listing options for sellers. So we're going to take a look at that change first. There's also one other change that we'll talk about too regarding paragraph 10A. So looking at paragraph 5 and 6, this looks slightly different from what we have already seen, but the language is the same, other than we're saying now the seller and broker agree to adhere to each local MLS's policies and further agree to execute any applicable forms as necessary. So that's the same language in paragraph 5 that we implemented in the exclusive right of sale listing agreements, which are already available to you, which is why this probably looks same or redundant, but it's, again, different form, same language. In this instance, though, we have to look down to paragraph 6, just like we do in those other listing agreements that have already become available, because in the language here, this is for broad public marketing. So we're telling you what it includes down here at line 55, what public marketing includes. But we had to add extra language because if we just said IDX or VOW, that would not be completely compliant with this MLS policy for listing options for sellers. So we added additional language to have, again, kind of working with that in paragraph 5, noting that unless the marketing options pursuant to local MLS rules apply. So again, if we've chosen this to do a delayed entry or delayed marketing, this language will then have that flexibility there for you. Again, it's just coverage to be compliant with the MLS policy, as well as to give you that assurance that we're going to agree to do what the local MLS rules are and follow their policies. The next change in paragraph 10, in theory, when these forms and the listing agreements were being looked at during 2024, before the settlement changes were implemented on that August 17th date, there was a concern or there was a thought that we could check all. You could actually check more than one option. You could check A and B, though in practice, that has not been what has come to fruition after the settlement, as we've seen and heard from committee members or members who've spoken to the committee about how they're using this form. So the option is now to say check one option, one of those three, not multiple. Again, you're likely doing this in practice, and that's why this change happened, but just want to draw your attention to it. Okay, we're going to move on to a new listing form, a different listing form. Again, same language, just new form. So this is the limited service listing agreement, not always widely used, but again, could affect the new NAR MLS policy. So in this paragraph, paragraph 4 at the end, it's going to read the same. The seller and broker agree to adhere to each local MLS's policies and further agree to execute any applicable forms as necessary. Again, nothing earth-shattering. You've seen this language. You're just going to continue to see it. And as I mentioned, this is about consistency across the forms platform. So all of these listing agreements are now going to consistently have that same language. And we're going to follow it up with the vacant land listing agreement. Now, paragraph numbers might change, but the language is still the same. So just know it's here again for consistency's sake that the seller and broker agree to adhere to each local MLS's policies and further agree to execute any applicable forms as necessary. Now, we're going to move to the exclusive right to lease listing agreement. Again, the only change here, and the fact that it is blue does not change that it is new language, it is still new, is just we're using the term owner. So because this again is a lease listing agreement, we're not saying seller, we're using the term owner. But otherwise, it's the same language. Once more again, being consistent across the forms platform. The other change here on this form that I do want to talk about is paragraph 6. So there was the removal of language around a sales tax. When some of our listing agreements were created, there was a talk in the legislature about creating a sales tax on services for real estate brokers and agents. The reality is it never came to fruition. There's never been a sales tax on real estate services. So we're removing language that's never really applied. So in practice, this is not going to change anything from your day-to-day business, but it's just streamlining the form. So again, minor change from your perspective, but just drawing your attention that if it looks a little different, that area looks a little shorter, that is why. The next form we're going to take a peek at is the exclusive right to sale listing agreement for commercial. right? Again, we're back to our same NAR MLS policy language for the multiple listing options for sellers. Again, nothing new and earth-shattering here, but again, now it's addressing it in our commercial listing agreement. So now we've got the change through the residential agreements, the vacant land agreements, our lease agreements, and our commercial listing agreements. So the listing forms are all now consistent with the same language. I know it's a lot and it looks like a lot of changes, but really once we understand it's the same change consistently applied, it can make understanding them a bit more palatable. So we're going to move to the third bucket, committee approved updates. Again, these are your peers who are spending relentless time in trying to ensure that the forms are just as current as your practice. So before I jump into some of these changes, I just want to have a refresh. There are 4 different versions of your exclusive buyer brokerage agreements. These are not including your the showing agreement or the property pre-touring agreement. Those are 2 separate forms. But the exclusive buyer brokerage agreements are highly used by our members. And so we want to make sure you're just in broad category understanding the 4 different versions. So we have the exclusive buyer brokerage agreement, consent to transition to transaction broker, exclusive buyer brokerage agreement for the no brokerage relationship, and the exclusive buyer brokerage agreement, single agent. And lastly, and mostly used, is the exclusive buyer brokerage agreement, transaction broker. So there is one agreement for each type of agency relationship you can create under our Florida laws. Though keeping in mind, transaction broker is far outpacing the other 3. So now that we know that we have 4 different forms, the changes we're going to cover in the next couple slides are going to address all 4 of these. So they're all going to be consistent, again, between these 4 forms. And so the first thing we should take a peek at is some removal of language in paragraph 5B. So that we have removed some language, and then there's going to be an addition to language. So this change here was brought to the committee through a suggestion, I believe, but we have multiple discussions in the committees about this language. And so the committee ultimately voted and the leadership approved to remove the statement that says consumer authorizes broker to run a credit check to verify consumer's credit information. Now, just want to ensure that you know, even though the language has been stricken from the form and is removed, that does not mean as a broker and a consumer, you could still agree to this. So if this is part of your business model and you choose to do credit checks and choose to run them as the broker, you can add these to your additional terms. Because this was not legislative, this is still a negotiable term. So just want to draw your attention that it may not be in the standard form itself, but it is still a viable option for your business model if this is how you choose to practice and you, as a broker and a consumer, agree to continue to do this. So just want to make sure you're aware of that fact and that point. The next change to this form was pretty exciting for the committee as we were contemplating what is currently on properties. And as I was a realtor well over 10 years ago, it was less prevalent then, but it certainly has become an issue now. So the committee felt it was important to put an acknowledgement here in the same buyer section in paragraph 5, saying, buyer, you're really acknowledging that property owners may have audio recording or video surveillance equipment on a property. And we give the example of cameras with audio recording or doorbell cameras, or ring cameras, those kinds of things. And that the consumer will exercise caution while viewing such properties. We have heard many calls on the legal hotline where buyers have said things that were not necessarily appropriate on the property, criticizing the property or criticizing an element of the property, and the seller has heard it. And negotiations don't tend to go well after that. So the reality is here is to put buyers on notice that these things exist on the properties pretty commonly. And again, buyer to use some, whether it's restraint, but use caution while viewing properties. And maybe best not to say anything until after you leave the property. So, and the last small change here is just to be similar to the exclusive right of sale listing agreements, where at the end of the listing agreement, there's a way to say the return copy to seller, and the seller has a copy and how we're going to return it. The committee felt it was important to be, again, consistent. So we've added this small bit to the very end. This will be after where the buyer signs on the buyer brokerage agreement to just say that, hey, consumer, we've provided this, and this is how we delivered it to you. Again, just as a method of having that assurance that we've done our portion to ensure the buyer or the tenant, as the consumer, has received the form. So again, These are things that the committee was very passionate about, again, in being consistent and ensuring to keep consistent with the way the business practices are going. So, in being consistent, the showing agreement has also been updated with the removal of the brokers running a credit check language. Paragraph number is different, but the language that is stricken is the same. Again, this is one of those things that a consumer and the broker may continue to negotiate using the additional term sections or however they choose to put it there. But they can still do this because it's not a legislative change. The law didn't say we couldn't do this. This is a choice. So the reality is, if this is part of your business models, certainly go ahead. You can still negotiate it and still add it in as a term if you choose to. The next form I want to discuss with you is the Milestone Inspection Structural Integrity Reserve Study Disclosure. So this form is recently created as of 2025, the early 2025. And so the committee felt it was worth looking back, now that they've looked at the seller's real property disclosures forms, to put a notice for the parties and the licensees that only the seller should fill out this form, right? And then to ensure that you know that this disclosure is not a contract itself, and it's not intended to be part of the contract for sale and purchase. This form is really to be used in conjunction with, similar like a seller's real property disclosure for residential or the condominium form, but it complements those things. It complements the condominium writers to the contract, but it does not replace them. So it's an optional additional form you could choose to use. The committee also realized we needed to be more specific about where this disclosure is going to attach. So they included property location information and the association information to better identify the property in which we're giving disclosure about. So again, just know that this is an additional form that can be used. It's not required, and it does not replace your sales contract, nor does it replace the condo rider or the seller's real property disclosure. It just complements those things. Next, this is going to look like a lot here on this page with all this beautiful red text, but this change is really, again, about consistency. So the Forms Committee looked at the commercial contract and the contract for residential sale and purchase, or what we call the CRISP. It is the non-FAR-BAR residential sales contract. And so in those two forms earlier in 2025, they had agreed to change the timing to calendar days. Well, the vacant land is doing the same thing. So now we're saying this is a calendar day contract where the property is located, because we know that there are two potential time zones you could be in when using this form in Florida. So the goal here is to remove, and you'll see this at the beginning of that paragraph where all that strike through is that we're removing any kind of bifurcation, meaning we're saying if the time was less than 5 days, we're going to use business days in counting. We're no longer using business days. Calendar days 100% of the time. The one change we're adding towards the bottom of the paragraph is what happens when that time period or that due diligence period ends on a Saturday, Sunday, national legal holiday, or a day of national legal holiday is observed. We say it's going to move to the next business day. So as we just observed the Christmas holiday, if Christmas was on a Monday and your time period ended on a Monday, it would not end on that day. It would move to the next calendar day. So it's going to read more consistently with these, with the commercial form, with the CRISP form, and even similarly to the FAR-BAR and FAR-BAR as is contracts. Again, bringing consistency across the sales contracts platform in your forms library. So no more wondering if we're using business days or calendar days. It is calendar days. And so this brings us to our last bucket, but we're not quite done yet. So again, form suggestions. We get form suggestions, or the committees get form suggestions throughout the year. The committee hears them as soon as they can, and as quickly as they can, and deliberate about them. So this time around, we have one form suggestion that has made it. And I want to give more explanation and time here, because the contract-to-lease form, not always the most used, or maybe not always the most understood. So paragraph 1 of this form, before we get to this change, is setting up who the parties are, right? We're talking about the landlord, the tenant, when they might be putting the lease together. Then we get to paragraph 2. And this is a paragraph about a deposit for the contract to lease itself. It is not the deposit for the lease. That's addressed in a separate paragraph in paragraph 5. So the concern with this suggestion, once it was heard, was that the language was limiting, saying that, hey, if I am a tenant making an offer to a landlord using this contract-to-lease form, it says tenant has paid, meaning already given money to the deposit holder. Typically, that might be the broker, or it could be a title, an attorney, somebody like that. But the reality was, if the tenant hadn't done it, they were already behind the ball on performance. So this suggestion was, hey, why don't we start looking at how can we be compliant, or we're going to make this offer to the landlord and we will make the payment within the next 3 days once we sign the contract to lease, knowing that it will happen. So we've given an option. And so you'll check one of the two. If the tenant has already given money to the deposit holder, again, maybe their broker, great, check the first option. Check the second option if the tenant is talking about it and they will do it in the next 3 days. And it can be, again, the amounts are negotiable, the terms are negotiable. We just wanted to give flexibility in the options. And so, and again, even like it mentions here, it will potentially still get credited. This deposit could still be credited to the lease under that paragraph 5 below. But this deposit is really about the contract to lease itself. So in the off chance your landlord and tenant do not execute a lease within, let's say, 2 weeks as they've agreed to, the reality is this is the deposit that would be in question if one of the two parties does, or if the tenant doesn't perform. So if the tenant says, I'm just not going to move forward, I don't want to go through with this deal, that's the deposit that could be potentially an issue for non-performance. It's what's in paragraph 2, not in paragraph 5. So again, this gets a little tricky, but just know that this is really about giving options to the tenant in and how they choose to make their offer to the landlord using this contract to lease form. And so that's really the main suggestion that we've been working with. But I do want to bring in kind of a fun concept as we're getting closer to, we've just ended the year. So out with the old and in with the new. So there's going to be something I want to address here for you. So compensation agreements, right? Compensation agreements were a pretty big topic during 2024 as preparing for the NAR settlement deadlines, for forms to comply, and then as we rolled them out. And so in that time crunch, a lot of form changes were happening all at the same time. So what was created for the purpose of having these compensation agreements once the MLS was no longer an option were these agreements for between the seller to buyer's broker and a compensation agreement for seller's broker to buyer's broker. These two forms accompanied the two options in paragraph 10A and 10B in the exclusive right of sale listing agreement. And then, because we had two compensation forms, we had to have two modification forms, one to modify each form. So then we had two compensation forms, and then we had two separate modification forms to each of those forms. So it is important to know this is what we had, past tense. These are all retired from the forms library on Form Simplicity. In the consistency and streamlining and simplifying concept of the committees, we have streamlined these 4 forms into 2 forms. So note that these 4 forms are no longer available. If you have saved them somewhere in a package in Form Simplicity, you may still have access to them, though we do not recommend using old forms. We do recommend updating to the new forms. So here's what we had. Let's look at what we now have. So what's new? The committee came up with a combined compensation agreement for residential transactions. We have a combined form in the landlord-tenant area. It's the compensation agreement for landlord or listing broker to tenant broker. And so the concept is if we have one form for landlord and tenant, why do we need 2 forms for buyers and sellers? Hence, here we have 2 forms. We've combined them. So now you're going to see the form called compensation agreement, seller or seller's broker to buyer's broker. So it can work for both situations. And now we've reduced it down to 1 modification form. So we've lost 4 forms and we've only gained 2, which again, we're streamlining and we're being consistent. So I want to walk you through these a little more closely because they're going to look similar to what you're used to from the past year and a half of use, but there are some new things that I just want to make sure you're aware of. So this is the first part of the form. This is the compensation agreement itself, seller or seller's broker to buyer's broker. So you're going to notice under the party section under paragraph 1, you must choose seller or seller's broker. There is no default option. So to avoid confusion, to avoid enforceability issues down the road, when there may be a dispute, you need to check one of these two boxes. It is incredibly important. So, and actually critically important, because again, enforceability rides on this, and other terms in this form are going to rest on this. So paragraph 1, you must pick one of the two options. And then we named, if the seller is checked above, then check one of the following: whether the property is listed by the seller's broker, and then you can put the property, right? Or property is not listed. Sometimes a commission agreement may be used to work with a seller, and they never actually listed the property. So they may not want to say, yes, I've listed a property with you, when they never in fact did. So choose one of those two options again. There is no default. We need to ensure that we're accurately checking a box. So this is the combination portion. So make sure not to skip these boxes, look at them critically, and make sure that you have one of them checked before moving on to the next paragraphs. So we're going to look at paragraph 4. This is where more change happens. So I just want to draw your attention. This is not changed, but we're talking about when is this enforceable? When is this going to take effect? And we say it's delivered to all parties to this agreement. So we need to get it signed and sent back to the opposite parties who are affected. And then we changed one part, the term. In the previous agreements, it said 30 days. If left blank, 30 days. It has been reduced to 15 days. As members were using this in practice, this was discussed greatly amongst the committee members. How long of a time do we want to have these compensation agreements open? So it was reduced from 30 to 15. So just know that if you're used to 30, you're going to need to use the blank to fill it in. Otherwise, it is fully negotiable. It could be 1, 5, 10, 25, 65, doesn't matter. But just know if you say nothing and you leave it blank, the default will be 15. So under the paragraph 5, we get into the buyer's broker compensation. You're going to notice that it says seller or seller's broker as specified in paragraph 1. This is why those checkboxes matter, because we're saying who will compensate the buyer's broker. If we've checked nothing, maybe no one is, because it was maybe assumed. So again, we don't want to create enforceability issues. Check those checkboxes in paragraph 1. And then it gets even further. We say seller or seller's broker, as specified in paragraph 1, agrees to compensate buyer's broker. And then we're going to check one of those options again. Compensation is not set by law and is fully negotiable. And that is the place to do it. We just want to make sure to draw your attention to checking those boxes in paragraph 1. It was very important for the committee to ensure that we drew the attention there again to make sure that these forms are filled out appropriately. The next portion of this form is talking about dispute resolution and arbitration. Now, this looked a little different on the prior forms because we only had one option under each form. But now that it's a combined form, there are the two options. So if we have a seller who's agreed, because we checked the appropriate box in paragraph 1, that they will compensate the buyer's broker, the way to resolve a dispute between the two parties is mediation first. Mediation is a non-binding neutral third party to help the parties resolve their own dispute. If they cannot resolve it by themselves with this neutral third party as the mediator, then the parties can go to litigation. They're going to take it to court and have their day there. There is a way to sidestep litigation, and that's where arbitration comes in. Arbitration is binding, and it'll take place in the county typically where the property is located. So the reality here is if we would rather sidestep the costs of litigation, because it can be more costly, arbitration is an option, and the seller and the brokers can agree to this. The reality is we just need to initial the arbitration boxes. If you leave the arbitration boxes blank, you're going to litigation. We'll be in the mediation litigation. So only if you decide you want to sidestep the litigation, parties will all initial the arbitration section. So again, that's if the seller is compensating the buyer's broker. We then look down to the last paragraph here. If the seller's broker is compensating the buyer's broker, then we say we're going to initial these sections, but it's really talking about binding arbitration by a mutual agreeable arbitrator in accordance with the rules of the American Arbitration Association. And then it says, or if applicable, the most recent version of the National Association of Realtors Code of Ethics and Arbitration Manual. The NAR Code of Ethics and Arbitration Manual has 17 articles as part of the Code of Ethics. In Article 17, it refers to members, realtor members, agreeing to arbitration. So that is still in place at this time. And so that would be the appropriate place for two brokers who have a dispute to start potentially their arbitration there. Again, based on Article 17. So if you're not familiar with that and you find yourself in a dispute, go ahead and check back to the NAR Code of Ethics. They're available on nar.realtor, as well as the Code of Ethics and Arbitration Manual. And again, give it a look over because this is what you agree to as being a realtor member. So just want to draw your attention to that portion as well. The two different options. And again, just making sure we fill it out appropriately and that you initial the boxes if you're choosing arbitration if the seller is compensating the buyer's broker. Then we get to the miscellaneous clauses. No changes here. This is identical to what you're used to, but we do always draw the attention to making sure in having those conversations that brokers' commissions are not set by law and are fully negotiable. And then again, in no event will buyer's broker's compensation exceed the amount of compensation in a buyer broker's separate written agreement with buyer. This is not meant to override those documents. They're to work in tandem. And so keeping in mind, if you are on the buyer side negotiating compensation as a buyer's broker, be mindful of what's in your buyer brokerage agreement to avoid issues with your buyer based on that other form. So now let's take a quick peek at the modification. And I love to tell you that this is the last form for today. So we're going to take a look here. This is the modification to compensation agreement, seller or seller's broker to buyer's broker. And again, you're going to see we've got these combined check boxes again, seller or seller's broker. Once more, there are no defaults. So ensure that you've picked the appropriate box for your situation. Once we get past the parties, we have the check is applicable. All of these things remained the same. So none of these have changed since the last forms that you're used to. This will look very similar. And there's really nothing different. You just negotiate compensation as applicable or any other term to those agreements as you choose. And so we just want to make sure, again, none of this language has changed, but I just want to draw your attention that with the modification forms, it's all other non-conflicting provisions of that agreement remain in full force and effect. So if you have signed the compensation agreement, whether it's the seller or the seller's broker compensating the buyer's broker, the terms of that form remain constant as long as they're not in conflict, right? So if we've modified only one term, everything else still applies on that form. And that's what that's really meaning. So everything else will still be working together. These work as a modification to it. It's not going to replace it. So just keep that in mind that they'll only change what is conflicting, what you've changed here. Everything else remains fully in force and effect. And again, just the reminder that commissions are not set by law and fully negotiable. And so, but otherwise, this is the same form otherwise that you typically have been seeing with just those minor changes. So, and I mentioned that that's our last form. So I want to give you a few takeaways for today. And I know we've been going at this for a little while now. So the changes are live and available in Form Simplicity now. They're available now and they're ready to be used now, which means any of the prior revisions of these forms that we've talked about today have been removed. We do not keep old forms in the Form Simplicity library. We only put the new ones in there because, again, lawfully, there may be changes that were regulatory that are now needing to be used. So using old forms is not helpful to you. It can put you in much more legal risk, and we do not recommend you use them. So again, if you tucked old forms away to use on a rainy day in a package somewhere, you may want to look at revising your packages and ensuring you're using the most current forms on all of your transactions. Not only are the forms available in Form Simplicity, but our other forms licensed vendors like .loop, Transaction Desk, App Files, and the rest all should have these forms available for you today. If not, you can contact them and see when they will be available, but they have been produced. The couple last things, again, just a reminder, know the tools in your toolbox, right? We're only as good as the tools that we know that we have. Take time to review these forms as many times as you need to. They're, again, compensation agreements specifically, you're going to probably be using a lot. So make sure that you're aware of those changes, know how to use them, know how to implement them. And as always, if you ever have questions, your Florida Realtors Law and Policy team is here to help. There are 11 attorneys who are full-time with the legal hotline that are able to answer your questions about any of these changes. They're ready to, and they're standing by. So don't hesitate to give us a call and reach out if you have questions. And with that, I thank you so much for watching. And again, there's our number to the legal hotline. And if you want to find the forms description list, it is on our website. And again, in form simplicity for your viewing. Have a great one.